Hi, this is Corzine, your social media lawyer, and we're here to discuss today the Taylor Swift Shake It Off lawsuit. You're going to have to pardon me for my vocals and my video. My power went off in my studio at my house right before this broadcast, so I'm in the middle of a parking lot in Thousand Oaks, California. I'm dealing with some of the smoky air that we have in California. But welcome. Again, my name is Corzine, your social media lawyer. We're here to talk about the Taylor Swift Shake It Off lawsuit. We're going to talk about what's really shaken. There is a recent development, an important development with respect to this lawsuit that I think we all can learn from, especially us music creators. Before I begin, I want to say hi to some people that are here and also address this ambulance that's going by here. Oh my gosh. Captain Jack, good to see you. Ivan, how are you? Good to see you today. All right, let's get right to it. Taylor Swift, Shake It Off lawsuit. This is the title of our presentation today. I want to give you a little bit of background on this lawsuit. In 2018, there were two songwriters that wrote for a all-girl band that wrote a song that basically that's called "Play Is Gonna Play." In 2018, they sued Taylor Swift for copyright infringement. They claimed that the lyrics from their song "Play Is Gonna Play" was copied by Taylor Swift and any writers that she had help her, and as a result, Taylor Swift went on to make over $40 million in revenue from Shake It Off, and they say they're entitled to a large portion of it. And that's what happened in 2018. This song dates back to 2001. Again, it's called Play Is Gonna Play, and then they're arguing that Taylor Swift in Shake It Off stole the lyrics for the song. I also want to take a moment to say hi to Jozu. Good to see you. And Ignitement. Good to see you. Electro Petazor Games. The limits of free speech start with copyright in America. That's exactly right. And we're going to get into copyright, especially as it pertains to audio, music copyright in our discussion today. All right. So I'm getting some checks here saying my resolution is off, but I will change that. All right. So again, this involves Taylor Swift. The song was a 2001 3LW song called "Play Is Gonna Play." That was the name of the song that the plaintiffs in the lawsuit allege was copied by Taylor Swift. And I put before you in this little screen some of the lyrics here. This is the exact specific portion that the songwriters allege that Taylor Swift stole, and that is players they gonna play, and haters they gonna hate, ballers they gonna ball, shot callers they gonna call. Just so you know, I was thinking about putting some bits of the songs in this presentation today, but I decided otherwise because YouTube has been very, very strict with respect to audio, especially famous audio. So what I've done is in the links in the description section right now, you can actually listen, see the video for the 3LW song. You can also see the video for the Taylor Swift song, and you could listen to the music and the lyrics and assess for yourself. Is it a blatant copyright? Is it a blatant copy of this 3LW song? Oh, I also want to say hi to Tap Channel. Good to see you, Tap. And Family Jansen, good to see you. Stella Jawa, how are you today? We got Corley, hello. We got officially that one dude. What is up, dude? Why can't I make remixes now because of copyright? I know, it is really tough. I mean, I'm barely able to just show snippets of fair use type content on my channel, let alone doing full remixes. It's really hard. Fire Sale Gaming is here. Good to see you here. All right. Now let's get back to our discussion again about this lawsuit. Taylor Swift was sued by the creators of the 3LW song "Play Is Gonna Play." And this is 3LW. I don't know if any of you guys remember 3LW. I don't. I guess they had a couple songs that were in the top 100 way back in 2000 and 2001, 2002. But that's 3LW. That's the song, or that's the group that sang the song that the plaintiffs are alleging was stolen by Taylor Swift. So now we're going to move on to our lyric comparison relating to Taylor Swift's song, her 2014 song, "Shake It Off." And of course, you guys probably know this by heart. It was an anthem, or is an anthem, I guess, in America, because the player's gonna play, 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 and the hater's gonna hate, hate, hate. Baby, I'm just gonna shake, 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 shake it off, shake it off. See, I know you didn't bargain for this, but you get a demonstration of my singing skills. So we're just gonna go back and forth here. So we're looking at the lyric comparison between "Play Is Gonna Play." players are going to play, haters are going to hate, ballers are going to ball. So really, the argument is with respect to players going to play and the haters going to hate. Um, and actually, even with the first analysis, you know what? The second portion of that stanza for the 2001 3L song is not even the same as Taylor Swift's "Baby, I'm Just Gonna Shake, 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 Shake It Off." So that is really the basis for the lawsuit. I'm going to take you through a little bit more of the history right now, so you can just kind of see what is this the what we call procedural history in the law. In basically what happened was in 2018, the lawsuit was filed against Taylor Swift. Taylor Swift filed what's called a motion to dismiss, and that is a procedure that you do right before, you're not even going to trial, you're not even doing discovery, you're not doing depositions or asking questions of the other side. This is just straight off. Can this lawsuit go forward as a matter of law? She made this motion, and the judge, the U.S. District Court judge, I used to be a district judge, U.S. District Court, the U.S. District Judge clerk, so I have a good understanding of this. Basically said by 2001, American pop culture was heavily steeped in the concepts of players, haters, and player haters. The concept of actors acting in accordance with their essential nature is not at all creative. It is banal, not original enough. So the judge was saying he did his lyrics comparison, and he said, listen, it was not original enough. The 3LW song was not original enough to say that Taylor Swift had taken it. He basically said, by that time, those phrases, players, haters, player haters, all that kind of stuff, was boring, was really not original at all. And so as a result, Taylor Swift won. She won in 2018. She thought it was done. It didn't cost too much money because she just had her lawyers make a motion to dismiss, and the case was over. Now, let me just make sure I'm attending to everybody's here. Andrew's here. Good to see you, Andrew. Enlightenment, their group name sounds familiar. Yeah, I've never, to be honest, I love all sorts of music, and I'm surprised I haven't heard it. Lexi Mads, Ian, the new and better Taylor Swift. Yeah, I know. That's what we're going to talk about after this. We're going to talk about what you can do in the future if you're a music creator to avoid getting sued like this. Pokey Plays in the house. I got a text from here. How the heck that happened? Oh, Pokey Plays. If you're still there, at one point in time, you probably texted me, and I keep track of the text numbers, and so I just sent out a little release saying I'm going live right now. So that's why you probably got that. Oh, Jimmy, you got my text. Good to see you. Let's see if there's anybody else here. The View Chaser, hello. Good to see you. Fire Sale Gaming, good to see you. Give me a shot. Yeah, there you go. And Lexi Mads, good to see you. View Chaser, good to see you. All right, so let's keep on going with this thing. So in 2019, the case was thrown in. What does that mean? That means that a court of appeals, in this case, the Ninth Circuit Court of Appeals, basically said, listen, determining whether or not Taylor Swift stole the lyrics from the 3LW song is really a question of fact. It's really an analysis of originality, and originality is a question of fact. What is a question of fact? It's a question that a jury, or in some occasions, a judge has to decide later on in time after evidence has been produced to both sides. And so as a result, the Ninth Circuit Court of Appeal, they reversed and remanded. That means that they sent the case back to the trial judge for an analysis and for trial coming up. So what happened in 2020, and actually this, I think it was September 4th, 2020, the judge who got the case back, the trial judge, basically said after Taylor's motion to dismiss again, he denied that motion and said the case can go to trial. He said that there's enough discussion, factual question between the play is going to play lyrics here and Taylor Swift's lyrics here from Shake It Off, that he was going to let that case go to trial. Now, it's important to understand that this doesn't mean that it has to go to trial. The case could definitely be settled, or what was more often the case is Taylor Swift will make a motion for summary judgment or summary adjudication, and she will either eliminate the entire case in general after the evidence has been discovered and produced to both sides, or a portion of the case will be taken away. So the questions I have for you in our talk today are, please, when you get a chance, go into the description section and click on the links for both songs. I would love if you listen to both of them and listen if the music sounds familiar. Does it sound similar? Do the lyrics sound similar? And if you look at the actual written word we just discussed, it doesn't look that similar, but I want you to listen to the tone that was done. Did Taylor Swift capture that tone? Did she take that tone to make an epic hit for herself, and then 3LW would not share in those revenues? Um, One of the questions I had for you too is that, and I just use one of these words, but once someone uses the word playa in a piece of music, is that term gone? Are we not allowed to use players or playa or play or whatever, some variation of that? Is that fair? If there was some sort of very descriptive phrase used to talk about, the scene in a forest or the beach sunset or something like that, that may be different. But in this particular context, we're just talking about play is gonna play, hate is gonna hate. Are those phrases original enough that someone has a copyright in them? And if someone takes them and then makes some money off them, that money is owed to the original person coming up with players and haters. And then the other thing I want to talk about, but I want to say hi to Tater the bot. How are you? Good to see you. Who else is here from the scam text? My goodness, I didn't scam text. I just sent out a notice of the live today. You certainly don't. You could not join us. Um, let's see. Officially, that dude Taylor Swift got copyrighted, but the girl saying hello from the other side didn't. See, Taylor Swift got copyrighted, but the girl that's saying hello from the other side didn't. Huh. I'm not following you on that one, but we will let me know in the comments if there's something more. We got Trent the Hedge Dog. What's up, dude? Good to see you. Pokey Plays, gotcha. That will make sense. Well, I'm glad it happened because the information is quite interesting. Well, Pokey Plays, I'm so glad you're interested. I'm sorry for this. I'm in the back of my truck. I mean, I hope you guys can see right here. It's kind of lame here. I had this thing all set up, but that's what life is. Online Sales Funnel Academy, awesome knowledge. Thank you so much for coming out. I really appreciate that. Sue, SendStream. No, I don't think so. All right, I don't think so either. I totally agree. Let's see, Rat Flick Show, great channel. Well, thank you so much for joining us. I'd love for you to join us in more of our lives. I just love all our activity here. Soy Boy Norman, why are you promoting your live streams illegally with leaked phone numbers? Well, I don't think I'm promoting them with leaked phone numbers, but you certainly could block the number and then you won't have the problem again. Or you can tell me and I'll delete it. 01 Beaker Productions. When did, gosh, still a lot of discussion about text messages. All right, well, let me just kind of go through the final questions here for our talk. And that is, not all lawsuits have to end in a trial or a motion to dismiss. There can be a settlement, there can be a compromise because of the fact that there is some similarity between the 3LW and the Taylor Swift lyrics. Could there be a compromise? Would you guys consider, let's say Taylor Swift made many, many millions of dollars on the song. Could she throw $1 million the way of 3LW and settle this case? 3LW is fine. Taylor Swift won't miss the money, and everything will be okay. But then the next question is, should she? I mean, if she truly didn't steal these lyrics, then why should she be paying anybody? She's totally within her right to use these words in her song and make a hit. So it's kind of a double-edged sword. I'd love for your input in the comments on that. And then my other question is, what should Swift have done? What do you do as an artist? You want to make a song about players and haters. And you're worried that 3LW, or there was actually another lawsuit relating to these lyrics against Taylor Swift. What do you do if you want to use those terms and they're really integral to your song and you're worried about getting sued? Do you just walk away because you're afraid of getting sued? Do you use them but understand that there's a possibility that you're going to have to defend a lawsuit the other day? Or what if you were a Swift? What if you were aware of the song at the time you wrote the song? Do you really think she should have gone to 3LW and said, hey, can I have permission to say play is going to play, hate is going to hate? I mean, is that set a bad precedent so that now anytime anyone uses and, the, but, nor, for, that they're worried about getting sued? Shouldn't there be a much more high standard for originality of lyrics than is, proffered in this case by 3LW? So those are the questions that I have for you to ponder. And I'm ready. I'm open to your questions too about, let's say, do you guys make music? Are you ever worried about getting sued as far as melodies or lyrics? It would be interesting to hear what you have to say about that. Let's see here. Okay. Jennifer Isaacs, I have seen about how many get sued from the guy who debunks reverse lyrics. There have been so many lawsuits over music to other things struck. I know it's whether it be Katy Perry, whether it be Taylor Swift. There's a whole bunch of lawsuits. A lot of people, a lot of big music artists, they're kind of targets because they make so much money that people who have any relationship, they make it a song that sounds similar to any top song. It seems like it's just part of doing business as a big artist is to get sued. Anthony Goodley, hello, how are you? Rap shows. Ian is the best. Thanks for keeping it real. Well, thank you. I'm so glad you're joining. Um, Let's see, Jennifer Isaacs, call things a parody like Weird Al. Well, I love your thought on that because parody is definitely a portion of fair use that will get you out of copyright strikes on YouTube, that will get you out of copyright infringement lawsuits. However, you have to understand that if there's a dispute, if it's a questionable call of whether or not it's a parody or not, you may get sued just because of the fact that there's a questionable call, and the person who's suing may want a settlement someday because they know that it costs a lot of money to defend in trial. The other part is, why do you have to parody? I mean, is there some requirement that whenever there's some sort of similar lyric, player's going to play, hater's going to hate, that you got to parody that? Certainly, I could be wrong. I obviously didn't write the song, but it doesn't sound like Taylor Swift is doing a parody of the 3LW song, especially if you actually go into the description section and click on the links and listen to the music. It doesn't appear that way. So I say you're right that parody would be a good way to be able to get around a lawsuit or some sort of copyright strike online. However, I don't know that it should be required of people to do parodies just to get out of this stuff. Let's see, we have more. Carl's Energy, good to see you. Yo, why the heck? Okay, all right. Carl's is Energy. Sorry, you got the text. Lexi, let's see. Lexi Mad says, this is silliness. I don't think they're similar enough. First judgment was right. Yeah, the judgment from the judge, I think, was right too. It was interesting. If you read the opinion too, I think you'll really appreciate it. He made some kind of humorous, paragraphs, decisions in the actual order. So I think it's really worth it. Let's see. Ian said he texts people who had texted him in the past and thus had their numbers. Yeah, we have a text platform. So if you ever text me, then it keeps track and then I give you notice of lives. Let's see. Carl asked YouTube, just saying. All right. Anthony Goodley, I'm good. How are you? Good to see you. Vortex, hi. Good to see you, Vortex. Officially, that one dude. I got copyrighted for a lot of Eminem's leaked songs. Is that okay to be copyrighted by Eminem's leaked music that no one owns? Well, first of all, it's not okay to get copyrighted. But secondarily, remember what copyright law is about. Copyright basically protects artists, anyone like you and I, who do creations. And somehow, I want to make sure my time is right. Any kind of creations that we do are automatically protected under most laws throughout the world immediately after we do it. So if I write a blog post or something on this particular case, let's say, right when I'm done, right when it's become a tangible means of expression, then that is protected by copyright law. Now, you certainly can register your copyright, which is a smart move if you ever have to go to court to enforce your copyright. But that's so what I'm trying to get to is that Eminem's songs, even unreleased, are copyrighted automatically. So if you use his songs that are unreleased in your video or in your podcast in some sort of audio medium, maybe even a remix, then technically you're violating the law because you don't have permission. Now, if you're making a parody, if you're teaching about these Eminem songs, if you're doing commentary on the Eminem songs, then of course you could use the exception of fair use and not be liable under a copyright infringement claim or not be, victim of a copyright strike. But that's technically you do need permission. Doesn't matter what kind of art it is. Lexi Mads, Weird Al also licenses every song he parodies to make sure there's no copyright issue. Yes, Weird Al does have the ability because he has the resources to do that. Not everybody does. And frankly, the law doesn't require you license everything if you want to parody it. That's smart. But basically, the law really wants to honor our culture. And a lot of our art and our culture was built off of other art. And so it really, under First Amendment grounds, under freedom of expression grounds, under just cultural grounds, the law doesn't want to prevent people from building upon the art of others. But the law does want to protect artists from getting their stuff ripped off. So that's the distinguishing factor. When you're determining whether or not you want to have a video clip in your YouTube video or you want to put something in your podcast or maybe an audio clip, you really have to think, am I using this clip for the original purpose that the artist who created it used? Or am I doing something with this clip? I'm building upon it. So if it's a famous TV show, am I teaching about script writing from using this TV show? Or am I just using this video clip from a famous TV show to get a laugh, just like the person who created the TV show wanted? At that point in time, you're taking for the original purpose. But if you're building, you're commentating on it, you're critiquing it, you're using it for a news purpose, then at that point in time, the law says, listen, that's fair use, and that is admissible under the law, and you'll be able to, not be the victim of copyright infringement action. Let's see. We got another comment from Pokey Plays. Fun fact: Weird Al actually asked permission before he made. Yeah, that's right, he does. Let's see. Anthony Goodley. I think this text platform is very cool, especially considering the lack of reliability of notifications. Yeah, well, thank you, Anthony. I appreciate it. Yeah, I don't want to bug you guys. Never, ever, ever do I want to bug you guys, for sure. Um, Jennifer Isaac says, also copyright laws may vary and change over the planet. It really depends on what can be shared and how. Yes, it does. A very, very important point. It's very difficult for lawyers to give advice for locations across the world. It's very difficult for us to give advice for one city versus another city because the laws are many and they change by location uh, very substantially. So what my job is basically to kind of, teach the principles, the general principles of, in this case, intellectual property law or business law or entertainment law generally. And also, my discussion is given with the proviso that this is not legal advice. These are just general principles that you can use when you are doing your art online. That's all I want to do is help you guys do your art online. So exactly right. And one of the things I want to get to is that these laws are changing rapidly. A lot of creators come to me, they do consults. If you go to iancorzine.com, you can sign up for a consult with me. And they basically say, listen, Ian, I'm excited. I want to do a movie review channel or something similar, a video review channel, even a reaction channel. My first thought is, okay, have you really thought this through? YouTube was formed on reactions, on critique type channels, on using TV media or other media, bringing it into YouTube, joking around with it, commenting on it, reacting to it. That's what I was founded. However, over time, the people who own the media have gotten kind of angry and they basically said, you've stolen our stuff. And so as a result, they put their powers on the various social media platforms, whether it be YouTube or Instagram or Facebook, and really pressured them to say, listen, protect our copyright. That's why YouTube has this whole structure right now. If you're a creator, you know it, about uploading your video, making certain declarations about the video as far as the copyright, as far as the content. It's gotten very, very strict. And what I tell creators who want to start their movie review channel right now is I say, think twice. Original content is really the most safe way to do online content these days. Review certainly gets, like we've talked about in prior lives, review certainly gets views, no question about it. If you look at the top 100 YouTube channels right now, kids stuff, video stuff, and review channels. So no question, but it's risky as heck. And I've had consultations with large creators, 50 million subscribers. I mean, big, big, big stuff. And it's all based on review stuff. And they get one copyright strike. And I mean, this is dangerous. They have 50-person staffs. When you get to be at that level, you're making so much money. You're such a big company that you're all dependent. The whole business is dependent upon YouTube or some other social media platform. And if you get one strike, that really could affect your channel. And then certainly if your whole channel, you have 1,000 videos is based upon reviews, it's real easy to get 3 strikes in a row. And guess what? You're out of business at that point in time. So that's why you'll see we're doing a video. We did a video with Roberto Blake day before yesterday, and we talk about TikTok. But one of the main takeaways from our discussion is being platform agnostic. That's why I always advise you creators, make sure that you don't have all your eggs in one basket. YouTube is certainly a great resource. It's going to be around for a long time. You've seen my video where I predict that it's way better. It's going to last longer than TikTok and Instagram combined because of the searchability, among other things, and the fact they pay creators. But you know what? It just takes one video for YouTube to not like you and to go beep, terminated. And then you have no recourse. And if you've only put your eggs in one basket, the YouTube basket, then you've got a problem. So that's really important for you to be platform agnostic. All right, I'm trying to make sure where are we at now. We got 5 more minutes left, so I want to make sure We got all the questions answered. Jennifer Isaacs says, oh no, she says, oh yeah, then memes. Yeah, we could do a whole live on memes. This is so funny. I'm looking at myself in the screen and seeing the parking lot I'm in. Lexi Mads, Tom Scott made a great, yes he did. Tom Scott made a great video on how the copyright laws really need to be updated because they're written for big corporations, not individuals. Yeah, you know what, Lexi, I don't know if you can, but if you could drop a link to that video in the comments, because I encourage everyone to watch it. It was awesome. It also has some of my friends in it. Illegal Eagle was in it, and it was a great video. It really helps you understand copyright law, especially on YouTube. Jennifer Isaacs, is there blurry lines to what is copyrighted at times? I like blurry lines. Blurred lines at times, or even false claims about some on suing for copyright. Is there ways to defend against such a false DMCA or being sued for copyright, perhaps falsely? Yeah, I mean, there's a lot of issues there. And of course, you know, there are a lot of times I'm the person who's called upon to give advice concerning a false takedown request, DMCA takedown notice. What can you do? Well, the really only thing you can do is to take your argument. Well, first of all, I think it's really important that you speak to a social media lawyer or some intellectual property lawyer before. The reason why is that once you start doing a counter notification to a false DMCA takedown notice, then you start potentially subjecting yourself to federal jurisdiction and getting into legal things that you probably need to have some advice about. But I will say that your remedy at this point in time is with YouTube, and we've talked about the ways to inform YouTube, tweeting at Team YouTube, appealing the takedowns and the copyright strike. And then the other thing is also appealing to the owner, the copyright holder of the media that you're charged with taking. I've had some success, and my creator clients have had some success with going straight to them and saying, listen, I'm sorry, I took this 2-second clip. Uh, I thought it was good for my video, and I also thought it was good for your brand. It advertised your brand, and basically, I believe I did it because of fair use, and I was commenting on this, topic or something. And sometimes you can get their permission, and they will release the DMCA takedown notice. I would say this though, that it's really great if you got legal advice before you did it, because it does get a little bit iffy. Sometimes they ask you to sign a written release, and you're releasing things that you don't necessarily want to release. Sometimes you're requested to sign off your revenue. There's a whole bunch of different things you need to be considering before you do a counter notification. But there isn't really right now. There's not a strong plan for getting out of DMCA takedown notices. All right, let me just see. I'm almost here, dude. I'm so sorry. Yeah. Uh, Let's see. Antonio Rodriguez, good to see you here. Sorry if my question might be out of the realm of copyright. Just stumbled on your site. Well, no, don't be sorry. As a visual artist, when one paints on one's own reproduced art works substantially, when, if at all, be considered unique and original work on one's own reproducer. Well, I mean, again, if I'm understanding you, Antonio, right, if it's your work, then you have all the copyrights to do whatever you want, to alter, to copy, to distribute. All these different bundle of rights comes with your copyright to your own art. So I would not be worried about, making changes to your own art. The question comes when you're making changes, or you're using and you're putting before a big audience someone else's art without their permission. So the natural progression is, I want to use this, I want to cover this song. All right. So the natural progression is find out who owns the copyright to the song, approach them, say I would like to do this cover, and see if you can work out a licensing deal. Um, Short of that, you have a problem. Now, maybe you could buy the licensing off an agent of the copyright holder, but covering a copyrighted musical piece is not permitted unless you have a license. There aren't any really ways around that. People have argued, okay, what if I remix it? What if I change the instrumentation? That still impacts copyrights, and you may have a problem. So let's just see here what we're doing. All right, we got Cat Steel. Good to see you. I used to stream to YouTube until I got a copyright strike. Oh my gosh, I'm sorry. From a claim on a sound clip that was accidentally played through someone in my Discord, and it was so quiet, I had to go into Audacity and probably delete it. Oh my God, Cat Steel. That is so true. We're seeing that a lot more now. I was actually kind of scared because I'm out here in the middle of a parking lot. And if there is any background music here, YouTube is so sensitive through these, AirPods here, that it would probably put together a copyright claim on this actual live video. I'm just hoping we don't get one. But I'm sorry that that's the case for you. It's very, very common. Let me make sure I'm addressing everybody here. I don't stream to YouTube anymore. Copper system is bogus. Yeah, I don't blame you. I really don't. Antonio Smith, I don't think it's the words, it's the tone and how they are used. 3LW weren't the first in the business to use those words. Yeah, Antonio Smith, I definitely agree with you. Um, it is. It is true. I have not done like an in-depth analysis of when other people before 2001 used players and hate or haters in the chorus, but I gather it was done. I mean, I just remember from my own history that those terms were used for a long time, 20, 30 years. So I don't think, I do think the case will be settled ultimately. Just to kind of give you my prognostication, I do think the case will be settled ultimately. I think it is probably a money grab. Taylor Swift made a lot of money on this song. It is an anthem, and so frankly, I don't know what 3LW's finances are, but if they got $1 million or $2 million or something like that, I mean, my gosh, that's a lot of money for any of us. And so I think they're taking advantage of the system. I really do, because if you really look at the lyrics, and again, I encourage you to go in the description section and click on and listen to the 3LW song as well as the Taylor Swift song, and listen for yourself. But I think when you do, you'll see that they're not the same. I don't think Taylor was trying to copy it. And frankly, it's kind of, the intent is there. If you look at the second stanza of both choruses, they're totally different. There's no ballers in Taylor Swift's chorus. So I think the case is going to go away. All right, guys. We are at the end. I'm going to answer a few more questions. I had 7 videos taken down without warning for third-party privacy. I sent them to the president's agency's scientists. Very important. Oh my gosh. I'm so sorry. That sucks. And then finally, Anthony Goodley, I pay to use Epidemic Sounds music and sound effects in videos and live streams. Thoughts on such service? I'm a big Epidemic guy too. I do believe in them. One thing you got to make sure you do is read through the licensing before you use those type platforms like MusicBed or Epidemic in your videos, because some of them have this callback provision where as long as you have to subscribe to Epidemic for them not to claim your videos if you have the sound effects or the music in your videos. So got to be careful on that. But if you're comfortable with that, then I love it. I mean, especially Epidemic, great library. Use it all the time on lives, but mostly on my videos. So anyway, guys, thank you so much for joining me today. Again, my name is Ian Corzine, your social media lawyer. I'm here for creators and anybody, frankly, on the internet to talk about our rights to free speech, freedom of expression, and to help you guys understand the law so that you can make better, free video content, audio content out there, because my goal is for all you guys to be able to have a voice online, and it's been real difficult lately. So anyway, guys, thank you so much for joining me today. Again, if you want to get on my calendar and set up a consult, go to iancorzine.com. That's iancorzine.com. Otherwise, I will see you on Tuesday with Roberto Blake. I have a video coming up on the TikTok ban. Is it really going to happen on Wednesday? Is it really going to happen? Let me know in the comments if you think the TikTok ban is really going to happen.